PLS201, Legal Research and Writing for Paralegals. Week 4, Special Research Issues. Special Research Issues, Legislative History. When a court cannot determine the plain meaning of a statute, it will resort to reviewing the legislative history of a statute. The legislative history can be compiled by examining versions of the bill as it is passed through Congress, by reviewing the transcripts of committee hearings, utilizing committee reports, which are more reliable than hearing transcripts, and or focusing on debate remarks made in a congressional record publication. It is important to understand that legislative history will not be used to replace the statute itself, but will be used to help define or help find the plain meaning of said statute. There are 3 ways to obtain the legislative history of a statute. One can find the legislative history of a statute in print format. One can find the legislative history of a statute using electronic resources. And one may be able to obtain the legislative history by purchasing a prepackaged legislative history of said statute. There are alternative methods of obtaining legislative history, and those would include the following. One may go down to the local law library, consult with the librarian for assistance in locating annotated statutes, which would provide a history of that statute. One can use commercial services such as StateNet or Legislative Intent Service. One may contact congress.gov to locate and contact the staff of the representative who proposed the bill for information. And one may obtain legislative history by using law reviews and, as has been mentioned previously, annotated statutes. Another special research issue is international law issues. And that does not only deal with international law between international entities, such as the United States, Mexico, the United States, and England. It includes Florida and California, Florida and New York. For international law research issues, first review the issues. Second, determine if a treaty covers the issues, and if so, review the treaty to determine if it is still good case law. Remember, to shepherdize that treaty. And finally, read analyses of cases interpreting said treaty. This will assist you in international law research issues. PLS 201, Legal Research and Writing for Paralegals, Week 4, Part 2. Special Research Issues. Treaties. Treaties made by the executive branch under the authority of the United States Constitution is considered the supreme law of the land, and every judge is bound to the content of that treaty. Treaties can be located in a series entitled Senate Treaty Documents, or by using an online resource. Whether a treaty is still good can be verified by looking in the annual publication of the State Department entitled Treaties in Force, which is organized by country, the country with whom we have a treaty, and the topic of that treaty. To interpret a treaty, a paralegal should use both primary resources, such as case law that have interpreted treaties, and secondary sources, such as law reviews, annotated text reviews. Please remember that all federal courts follow the Federal Rules of Civil Procedure, known as the FRCP, or the Federal Rules of Criminal Procedure. Both contain rules on pleadings, motions, discovery rules, and information on both civil and criminal trials. Why is it important? Both the Federal Rules of Civil Procedure and the Federal Rules of Criminal Procedure lay out the guidelines by which one is to practice in said court. It is crucial that we follow the rules so that we, as a party, can succeed against opposing counsel. The digital library, Lexis, Westlaw, and non-print research sources. Competent researchers use and are familiar with all media, including traditional print, computer systems, and the Internet. Lexis and Westlaw are computer-assisted research services. The more familiar we become with Lexis or Westlaw, the more efficient our research will be. When conducting research, make certain to include the client's name so that he or she may be billed for the time spent researching a legal issue. When using Lexis or Westlaw, there is a feature. For example, in West, natural language, which will allow a paralegal to search for a legal issue in plain English. Understand that both Lexis and Westlaw are very similar, but both use different terminology when it comes to their search engines. As mentioned earlier, the more familiar we become, the more efficient we are. And why is that important? Because we need to remember billing. The more efficient, the less time researching, the smaller the bill. PLS 201, Week 4, Part 3, Legal Research and Writing for Paralegals. The digital library, Lexis, Westlaw, and non-print research sources. There are 3 ways to conduct research on LexisNexis. Those 3 ways would include the following: a traditional search using Boolean connectors, the new plain English method, and or the new easy search method, which is similar to internet searching. As with LexisNexis, Westlaw provides shortcut choices for research as well. But please remember, we should not rely on LexisNexis and Westlaw computer-based research alone. Paralegals should be familiar with print sources to avoid dependence on computer-assisted research. Westlaw and Lexis are not the only computer-assisted research sites. Some other examples of computer-assisted legal research sites include BloombergLaw.com, LoisLawConnect.com, FastCase.com, CaseMaker.us, VersusLaw.com, JurisSearch.com, and Pacer.gov are available. When we look to these assisted legal research sites, please look to .us, .gov, .edu as sites to be relied upon more so than those with .com. As mentioned, the best researchers will be those that use both print and computerized research methods. Internet research is indeed quicker for some research tasks. While the internet is a great way to conduct research, there is so much information that a researcher may get lost. And that is why efficiency is important. It is key to legal research. Legal research using the internet. A paralegal can use the internet to communicate. Communicate by email. The internet can be used to file pleadings or motions. The internet can be used to market the law firm or to promote yourself by way of LinkedIn and other social related media sites. It allows one to participate in continuing education courses. It allows one to order books or legal publications. As already discussed, it also allows one to conduct legal research. But when we discuss efficiency, when we do look at a .com, .gov, .edu, .us site, because there are so many, we should become familiar with one good start page, one that we are comfortable with, one that we are familiar with. This will aid us in starting our research quicker. PLS201, Week 4, Legal Research and Writing for Paralegals. Legal research using the Internet. As mentioned earlier in the lecture, the credibility of websites is very important, so the following things should be factors in evaluating a website. Look at the domain name. .gov and .edu are the most authoritative and reliable of all the secondary legal research internet services. Check the currency of the information. Are the cases cited or discussed current and valid? Check the author for his or her credibility. One way to do so is to be mindful of the appearance of the website. Is it a simple-based website? Be critical and look for errors in spelling, grammar, punctuation, quotation, and statistics. Consider the accuracy and depth of analysis of the site. Take notes and list sources as you conduct your research. Remember to use the history button or the down arrow to identify the URL for that page. Bookmark frequently visited sites and prepare a favorites list. Print long articles. Do not read those articles, as it will only consume more time. Be observant of missing information. Remember to never rely on the internet completely. Subscribe to only a few newsletters or blogs to avoid being overwhelmed with information. For example, I'm a member of the National College of DUI Defense, the Florida Association for Criminal Defense, and I receive emails from the web rings on a daily basis. And it can be overwhelming. Read the disclaimers for limitations. Use RSS feeds which provide instant updates via blogs or alerts from favorite websites. Now, going back to the use of email, we must remind ourselves of ethics. And by that, the internet, while making communication easier, is also fraught with, unfortunately, the ability of others to hack into such private information. And therefore we must obtain the client's permission to communicate by way of email when using email or electronic communication. By obtaining permission, we reduce legal liability and the potential for a malpractice suit against your attorney. Now, after we have gone through a thorough and exhaustive use of the internet for our legal research, and that information has been located, don't forget to actually read and analyze the information. It will be the one and true way of generating the best information for you to use in your work. Thank you.